Mlva Veleva, Chapter 22. 1. This is the order in which debts are collected. When the creditor brings his promissory note to the court and the authenticity of the witness's signatures are verified, we tell the borrower pay. We do not attach his property until the creditor demands this. If a judge errs and gives the creditor access to the borrower's property before he demands it, we remove the creditor from it. If the borrower responds, I will pay, establish a date for me so that I will have time to borrow money from another person, offer my land as collateral, sell property, and bring the money, we grant him 30 days. We do not require that he bring security to the court, for if he possesses movable property, the court would expropriate it immediately. If the creditor desires, he may have a conditional ban of ostracism issued against anyone who possesses money or valuable or movable property and uses arguments to avoid payment. We do not require the borrower to bring a guarantor until he pays. If the borrower has not brought payment when those 30 days are concluded, the court composes an adrachta. Similarly, if at the outset, when the lender demanded payment of him and he said, I will not pay, we compose an adrachta against this property immediately and do not grant him any time. Similarly, if what is involved is a loan supported by a verbal commitment alone and the borrower admits his obligation, we compose an adrachta against the property that is presently in his possession. 2. The following rules apply when the borrower claims the promissory note concerning which the signatures of the witnesses was validated is a forgery. I will bring proof and nullify the matter. The witnesses are located in this and this place, and their names are so-and-so and so-and-so. If it appears to the judge that there is substance to his words, a time is established in which he must bring his witnesses to court. If it appears to them that he is merely raising deceptive arguments and fallacious claims, they should tell him, pay. Afterwards, if he brings proof of his claim, the money should be returned to him. If the creditor is a man of force and it is possible the money will not be able to be recovered from him and should be trusted to a third party. 3. When a time was established for the borrower to bring proof and nullify the promissory note, that time came and he did not come to court. We wait 3 days. Wait for 3 court sessions, Monday, Thursday, and Monday. If he does not come, we compose the peticha against him and place him under a ban of ostracism. We give him further respite of 90 days while he is under a ban of ostracism. The first 30 perhaps he is seeking a loan, middle 30 perhaps he is seeking to sell property, and the final 30 for perhaps the person who purchased his property is seeking to bring him money. When these 90 days are completed and the borrower still does not appear in court, the court composes an adrachta against his property and releases him from the ban of ostracism. 4. If the borrower lives within a 2-day journey or less from the court, we do not compose an adrachta till we send messengers and inform him of this impending step. If he lives further away, it is not necessary to inform him. When does the above apply? When throughout the entire 90 days he would procrastinate and say, just now we'll bring proof that nullifies the promissory note. If whoever he says I refuse to appear in court, we compose an adrachta against both his movable and landed property immediately. Similarly, if a person is being sued on the basis of a legal document recording an object entrusted to him for safekeeping, we do not wait 90 days and instead we compose an adrachta against his property immediately. 5. The statements made above that if the borrower does not come at the conclusion of the 90-day period, we compose an adrachta applies only with regard to landed property. With regard to movable property, by contrast, different rules apply, even after 90 days. As long as the borrower says, I will bring proof and nullify the promissory note, we do not allow the lender to expropriate movable property. The rationale is that the alleged lender might consume it, and afterwards the borrower will bring proof that nullifies the promissory note, and then he will not find property belonging to the alleged lender that he can collect for repayment. This applies even if the lender possesses landed property, for perhaps that property will decrease in value or become dried out. 6. How is the adrachta composed? If we are expropriating property that is in the borrower's possession, we write in that document, so-and-so is obligated by his judgment to pay so-and-so this amount. He has not made this payment on his own volition, hence we have composed this adrachta against this and this field that he possesses. Afterwards, 3 experts evaluate a portion of that field equivalent in value to the debt that he owes, and its prospective sales announced according to the appraisal until those who add to the estimation make their bids. If there are no buyers, we transfer ownership of that portion of the field to the creditor because of his debt and rip up the promissory note if such a document existed. If there was no landed property in the borrower's possession, we compose the adrachta which states, so-and-so undertook an obligation to so-and-so as recorded in the promissory note produced by the creditor. The debtor has not paid this debt. We have not found property that is presently in the debtor's possession. We have already torn up the promissory note that the creditor possessed and have given him license to seek out and research whether there are any properties that the debtor sold from this and this date and onward, with the intent that his hand be raised over them. He has license to derive payment and expropriate his debt from all such properties. 7. After this adrachta is composed, the lender goes and seeks property belonging to or that once belonged to the borrower. If he finds property that is in his possession, they are evaluated for him. If he finds only property that has been sold after the date of the promissory note, he may expropriate it. We tear up the adrachta and write a tirpa. 8. How is a tirpa composed? We write, because of the debt of this and this amount that so-and-so owes him, so-and-so won in court the right to expropriate this and this field that so-and-so purchased for this and this amount at this and this time. We have already torn up the adrachta that was in his possession. We have given him license to expropriate this and this amount from this property. 9. After the tirpa was written so that the lender may expropriate the property, we bring 3 experts to that field to evaluate that field and appraise how much of the field should be given to him for the principal, and half of the field's increase in value, as explained. We then announce the property's sale for 30 days in the same manner as we announce the sale of property inherited by orphans. 10. Afterwards, if the borrower is with us on the land, we require the borrower to take an oath that he is bankrupt as ordained by our sages. We also require the person expropriating the property to take an oath while holding a sacred object that he did not collect payment for this debt, that he did not waive payment of it, and that he did not sell to another person. Afterwards, we give the lender possession of the purchasers according to the assessment of the debt owed him, and we compose a hardoda. 11. How is this document composed? The judge is right. After we have an evaluation of the property made for so-and-so because of the debt he was owed, we announced the sale of the property as it is fitting, and we required both the person expropriating the property and the debtor take the appropriate oaths. We have given so-and-so possession of this in this field. He may use it as a person uses property that he has acquired. 12. From which time a person who seeks to expropriate this property derive benefit from its produce from the time the days of the announcement are completed. 13. Whenever the adachta does not state, we have torn up the promissory note. It is not an acceptable adachta. Whenever a tirpa does not state, we have torn up adachta. It is not an acceptable tirpa. Whenever a shuma does not state, we have torn up the tirpa. It is not an acceptable shuma. 14. When 3 experts descend to evaluate a property, one evaluates it as worth a money, 2 evaluate it as worth 200 zuz, and one evaluates it as 200 zuz. Or one evaluates it as 200 zuz, and the other 2 evaluated as worth a mana, the assessor who offers the loan opinion is considered insignificant. If one assessor evaluates it as worth a mana, another at 80 zuz, and the third at 120, it's considered to be worth 100. If one says 100, the second 90, the third 130, it is considered to be worth 110. This is our pattern of evaluation. 15. When the court evaluated property belonging to a purchaser on behalf of a person who sought to expropriate an error, even if the error was concerning the smallest amount, the sale is nullified. The rationale is that since the court is considered to be an agent of the person expropriating the property and the purchaser, they have permission to expedite the matter, but not to impair anyone's position, as is the law applying it to an agent. All of the halachic authorities ruled in that manner. 16. When the court evaluates and expropriates a property for a creditor, whether from property in the creditor's possession or property that was in the possession of the purchaser, and afterwards the borrower, the person from whom the property was expropriated, or the heirs acquires financial resources and pays the creditor his money, the creditor is removed from that land. The property for property that was evaluated and expropriated shall be returned to its owners, as mandated by Deuteronomy, and you shall do what is just and good. 17. When a court evaluates and expropriates a property from a creditor, and then evaluates and expropriates a property from a creditor and a creditor of that creditor, the original owner can redeem it. The legal power of the second creditor is no greater than that of the first. When a creditor stole the property expropriated for him, gave it away as a present, or gave it to his creditor voluntarily, or he died and the property was inherited, the original owner does not have the right to redeem it. If land the property was evaluated and expropriated for a woman, and then she married, or the property she owned was evaluated and expropriated from her, and she married, her husband is considered to be a purchaser with regard to her property, he is not required to return it, nor must it be returned to him. Chapter 23. 1. Promissory notes that are predated are invalid because they will be used to expropriate property from purchasers in an unlawful manner. Accordingly, our sages penalize the lender, ruling that he may expropriate only property in the debtor's possession with a predated promissory note. This is a decree enacted unless he expropriate property from the first earlier date. 2. Post-dated promissory notes are acceptable, for the legal power of the possessor of the promissory note has been diminished. For the lender can expropriate only property from the date of the promissory note, even if document does not state that it was post-dated, it is acceptable. 3. When a promissory note is written during the day and signed in the night that it follows it is unacceptable because it is predated. If however the borrower and the lender were involved in negotiating the matter until night fell and then they signed, it is acceptable even when the kinyan was made at night. 4. When a promissory note is dated on the Shabbos or on the 10th of Tishrei, we assume that it was post-dated and that it is acceptable. We do not suspect perhaps that it is predated, was written on Sunday or on the 11th of Tishrei. Instead, we accept the presumption that the promissory note is acceptable. The rationale is that it is known that legal documents are not composed on the Shabbos, therefore it was post-dated. 5. We may compose a promissory note for the borrower even though he is not accompanied by the lender. We do not, however, compose a promissory note for the lender unless he is accompanied by the borrower. When does the above apply? With regard to a promissory note that was affirmed by a kinyan. For from the time the kinyan was carried out, the borrower's property was on lien. When, however, a promissory note was not affirmed by a kinyan, we do not compose the note even for the borrower unless he is accompanied by the lender and he gives the note to the lender in our presence. The rationale is that we suspect that the borrower may have the document composed at this time so that he can take a loan in Nisan, but in fact the loan will not be given until Tishrei. Thus, the lender will be able to use this promissory note to expropriate property that was in the borrower's possession unlawfully from Nisan, although the promissory note did not enter his possession until Tishrei. 6. The following rules apply when witnesses perform a kinyan with the borrower, the seller, or another person involved in the business agreement, but the composition of the legal text was delayed extensively. If they remembered the date on which the kinyan was established, they should write the date of the kinyan in the legal document, even though it was not the date that they signed the legal document. It is not necessary for them to state in the document, our signatures were delayed until this and this date. If the witnesses do not know the date on which the kinyan was performed, they should date the legal document from the day which it was composed. Similarly, witnesses who observe a business transaction in one country and compose a legal document in another country should not record the place where they observe the testimony in the legal document. Instead, they should record the place where they signed the legal document. 7. When deeds of sale are not dated with the date of the transaction, even those that are post-dated are not acceptable. The rationale is that the purchaser may use them to expropriate property in an unlawful manner. What is implied? For example, the seller could have repurchased the field from the purchaser before the date of the post-dated deed of sale. The purchaser could then produce the post-dated deed of sale and say, I returned and purchased it from you a second time. He could thus expropriate property from a purchaser unlawfully. Why don't we harbor the same suspicions with regard to a post-dated promissory note? It is possible the borrower paid the lender before the date stated in the promissory note. The lender will write him a receipt and then produce the promissory note and expropriate property unlawfully. We do not harbor such suspicions because whenever a person composes a post-dated promissory note, he can protect himself by having the receipt composed without a date. Thus, whenever the lender will produce the promissory note, the borrower can nullify it by producing this receipt. If the borrower did not do this and allow the receipt to be dated to the date when the debt was repaid, he caused himself a loss. 8. When a person was compelled to sell his field against his will and issued a post-dated or issued a protest or hurried and sold the field or gave it away to another person before he sold it to the person who compelled him to sell it, the money that the person who compelled him to sell it gave him is considered to be a loan supported by a verbal commitment to loan. He may not use that deed of sale to expropriate any property that has been sold by the seller to others. This law was stated because this deed of sale should not have been written, and it was only written under compulsion. Similar laws apply in all analogous situations. 9. It is possible for a person to expropriate property without a legal document merely on the basis of verbal testimony. What is implied? If a person has witnesses who will testify that property was stolen from his father, he can expropriate the property on the basis of this testimony, although there is no legal document. Similarly, if witnesses testify that a judgment was concluded for his father to expropriate property from so-and-so for this amount, this and this time, and his father died without expropriating the property, the son may expropriate property on the basis of this testimony. 10. Therefore, we should never compose two deeds of sale for the same property unless the purchaser perpetrate deception together with the creditor and expropriate property unlawfully. What is implied? The person will expropriate this field from the purchaser based on testimony that his father had the right to expropriate it. The purchaser will then use one deed of sale that he possesses to expropriate property from people who purchased property after he died from the borrower who sold him the property. The court will tear up the deed of sale that the initial purchaser possesses. For the sake of deception, the person who expropriated the field will allow the purchaser to take possession of it again. He will then expropriate it again on the basis of the testimony of his witnesses. The purchaser will then produce his second deed of sale and expropriate property from other purchasers unlawfully. If so, what should a person who has lost his deed of sale to a property do if the witnesses to the sale are still alive? The second deed of sale should be composed saying this deed of sale may not be used to expropriate property that has been sold or property that is in the possession of the seller. We have composed it only to establish so-and-so the purchaser is the owner of the field so that the seller or his heirs cannot expropriate it from him. 11. This principle does not apply with regard to promissory notes. Even though witnesses to the loan are alive and entered into a kinyan with the borrower, if the lender returns immediately and tells the witnesses the promissory note that you composed for me now is lost or was burnt, they should not compose a second promissory note for him. We suspect that was paid or that he waived payment. The above applies even if the loan was given for a period of time. The lender cannot collect any money on the basis of the testimony of his witnesses unless the borrower states the loan was never given. In that instance, he is established as a liar through their testimony, as will be explained. 12. When a promissory note in a person's possession was worn, and that is belonging and is beginning to become effaced, the lender should have witnesses look at it. He should then come to the court, and the court will validate it. The witnesses who signed the promissory note itself, however, may not compose another promissory note on their own initiative, even when the promissory note was blotted out in their presence. Instead, they should go to court, and the court will validate the promissory note. 13. How should this promissory note be validated? The court composes a new document that states, we, the court, composed of so-and-so and so-and-so and so-and-so, saw how so-and-so, the son of so-and-so, produced a promissory note that was faced in our presence. It was dated on this and this date. So-and-so and so-and-so are his witnesses. If they compose such a document that required testimony of the witnesses and the testimony was corroborated, the lender may collect the debt with this document that was composed for him. No further validation is required. The court did not compose such a document. If the debtor protests that the document is a forgery, the lender must also bring proof regarding the signatures of the original witnesses so that their testimony will be validated. 14. When a promissory note is torn, it is acceptable if its wording is in the process of being rubbed out or muddled, as long as it is in the form of the original letters are recognizable. It is acceptable. If it is torn as the court tears a legal document, it is unacceptable. In which manner does the court tear a legal document, both horizontally and vertically? 15. The following laws apply when a person repays a portion of a debt recorded in a promissory note. If the lender desires, he may exchange the original promissory note, and the court composes a new document for him for the remainder of the debt with a lien belonging on the original date, beginning on the original date. The witnesses to the original promissory note may not take this initiative. If he desires, he may write the borrower a receipt. 16. When a person comes to pay his debt and the lender tells him, I lost my promissory note, the lender should compose a receipt for him and then the borrower should pay the entire debt. The borrower may, however, have a ban of ostracism issued against anyone who hides his promissory note and claims that it is lost. If the borrower lodges a definite claim saying this promissory note that is in his possession, he just placed it in his pocket, and my masters have ruled that the lender should take a shvus hez that the promissory note was lost. Afterwards, the borrower should pay the debt, and a receipt should be composed. 17. When the lender produces a promissory note for a mana and asks that the two promissory notes of 50 zuz be composed, we do not comply. The rationale is that it is of the benefit for the borrower to have the entire debt recorded in a single promissory note. For if he pays a portion of the debt, the legal power of the promissory note will be impaired. Conversely, if the lender produces two promissory notes, each one of 50 zuz, and asks that the promissory note for 100 be composed, we do not comply. Instead, we validate both of them individually. The rationale is that it is a benefit to the borrower to have two promissory notes so that the lender cannot compel him to pay the entire sum at one time. 18. When the lender produces a promissory note for 100 zuz and says tear it up and compose another promissory note for 50, we do not heed his request. We fear that perhaps the borrower repaid the entire amount and the lender wrote a receipt for him. If the lender authenticated the new promissory note for 50 zuz and the borrower produced the receipt, he should tell the borrower this is another promissory note. Chapter 24.1. We have already explained that a promissory note concerning a loan that was affirmed by a king may be composed for a borrower even when the lender is not together with him. Similarly, we composed the deed of sale for the seller even though purchaser was not together with him. We compose a receipt for the lender even though the borrower is not together with him. We compose a receipt for a woman even though her husband is not together with her, and bill of divorce for a man even though his wife is not with him. We do not compose legal documents for consecration and marriage, sharecropping agreements, business contracts, the choice of judges, the claims of the litigants in any act of court without the consent of both principals. It is necessary to be careful about all the particulars of the composition of these documents, as is the case with regard to other legal documents too. Who must pay the scribe's fee for the composition of these documents? With regard to promissory notes, the borrower must pay. With regard to deeds of sale, the purchaser must pay. The woman must pay the fee for the bill of divorce. The groom must pay for the fee for documents for the consecration of marriage. The recipient of the field, the sharecropper, or the worker must pay the fee for the composition of contract. With regard to the document recording the choice of judges and the claims of the litigants, both parties must share the fee. 3. The following law applies both to legal documents composed for one of the parties when the other is not present, and legal documents that can be composed only when both consent and both are present. For instance, a promissory note written at the request of the lender or a deed of sale written at the request of the purchaser. In all instances, the witnesses must recognize the identity of the individuals mentioned in the legal document, that this is so-and-so, the son of so-and-so, and that this is so-and-so, the son of so-and-so, and so-and-so. This is necessary lest two individuals come and try to perpetrate deceit, changing their names to the names of other people and then acknowledge obligations to each other. For whenever a person has established a name for 30 days in the city, we do not suspect that he has another name and has changed his name to perpetrate deceit. For if we raise such suspicions, there would be no end to the matter. Therefore, if a person who has not established his name in a city for 30 days comes and asks, write a promissory note for me that I am obligated to so-and-so or to this person for these and these many dinar, we do not compose such a document for him unless he brings proof that this is his name or he waits until his identity is established. 5. The following laws apply when there is a dispute with regard to any promissory note produced before us. For example, the borrower claims that they do not owe anything. Maybe a charter pretending that his name was in my name and acknowledge owing money to this person. Or he might claim, I do not owe anything to this person, but rather to another person. This plaintiff is a charlatan in claiming that his name is the same as the name of the person to whom I owe. Since it has not been established that there are two people in that city with the same name, we pay no attention to his claim, for it is an accepted presumption that witnesses will not sign a legal document unless they know the identity of the people mentioned within it. Similarly, if it is an accepted presumption that witnesses will not sign a legal document unless they know with certainty that the person making these statements concerning themselves are adults and mentally competent. Witnesses will not sign a legal document unless they know how to read and sign their names. 6. When witnesses do not know how to sign their names, and the names of the witnesses were cut out from a blank paper and placed over the legal document, then the witnesses signed with this script. They are given stripes for rebellious conduct, and the promissory note is unacceptable. 7. When the head of the court of law knows about general circumstances described in the legal document, he may sign even though he does not read it himself, but instead was read to him by one of the scribes. The rationale is that the head of the court trusts the scribe, and the scribe is afraid no other person can do this. A witness may not sign a legal document unless he reads it word for word. 8. The following law applies when there are two people in a city, each named Yosef the son of Shimon. Neither of them can demand payment from the other on the basis of a promissory note that he produces, nor can a third party demand payment from either of them on the basis of a promissory note that he produces, unless the witnesses who signed the promissory note come and themselves and testify. This is the promissory note concerning which we testified, and this is the person concerning whom we testified regarding the loan. Similarly, such individual cannot divorce their wives unless do so in the presence of the other individual with the same name. Similarly, if a person finds a receipt among his legal documents saying this promissory note concerning debt owed to Yosef the son of Shimon has been paid, the debts recorded in the promissory note this person owes to both individuals with the same name are considered to be paid. What should people whose names and the names of their parents are alike do to enable themselves to compose valid legal documents? They should write the third generation as identification in the legal documents. If the names of their grandparents are the same, they should write a sign. If the signs also look alike, they should write the family lineage. If they are both priests or both Levites, they should write further generations. 9. The following laws apply when a person produces a promissory note against a colleague that states, I, so-and-so, the son of so-and-so, borrowed money from you. Although the name of the lender is not mentioned in the promissory note, any person who produces this promissory note from his possession can expropriate payment with it. The borrower cannot rebuff the plaintiff by saying that the promissory note belonged to another person from whom it fell. Similarly, when there are two people named Yosef, the son of Shimon, dwelling in the same city, and one of them produces a promissory note against one of the inhabitants of the city, the defendant cannot rebuff him by saying, I'm obligated to so-and-so, his name is the same as yours, and this promissory note fell from him. Instead, the person who produced the promissory note may use it to collect the debt we do not suspect that the promissory note fell. 10. The following laws apply when two persons produce promissory notes against each other. If the latter cannot tell the first, if I owed you money, why would you borrow from me? Instead, each one is entitled to collect the debt mentioned in his promissory note. If both of the promissory notes were for 100 zuz, both of the principal possessed property of equivalent value, be it property of superior quality, property of intermediate quality, or property of inferior quality, we do not tend to them. Instead, each person remains with what is his. If one possesses property of superior quality and property of intermediate quality, and the other only property of inferior quality, the one should expropriate the property of intermediate quality, and the other should expropriate the property of inferior quality. 11. Following laws apply when a person produces a promissory note against a colleague, and that person produces a deed of sale stating that the alleged lender sold him a field. If they are in a place where the purchaser pays the money, and afterward the seller writes the deed of the sale, the promissory note is invalidated. The rationale is that the borrower would tell the alleged lender, if I was indebted to you, you should have used the money to pay the debt. In a place where the deed of sale is composed and then money is paid, however, the promissory note is viable, for the alleged lender can claim, I sold you the field so that you would have a known property from which I could collect my debt if you claimed bankruptcy.